SJC-12406, Christine Hilton and others, v. Worcester Housing Court. SJC-12380, Ruth Adjartey and others, v. Worcester Housing Court. And SJC-12337, Marjorie Evans, v. Federal Home Loan Mortgage Corporation and another.
All right, good morning. Let me set the parameters. This is a bit unusual. As a hearing, we have three related cases. You may have noted that there were 7 justices hearing the other cases. There are 4 now. Each of the 3, I understand, were single justices on one of the 3 cases, and therefore they are recused from hearing this case because we are evaluating the decision of the single justice, and it is our practice that, of course, the single justice does not sit on a matter in which we are reviewing his or her decision, and because they are related cases, that means that each of the 3 have recused themselves from this decision. So, as you also may have seen, if you were watching the argument, we generally give 15 minutes per side with regard to the arguments. I gather that Mr. Keneally has worked hard with you in terms of organizing your time, so that we're going to begin with the Worcester Housing Court and then Federal Home Loan Mortgage, and then we'll hear from a number of the self-represented petitioners. There will be there's a light and a time limit. The practice is that is the time that we give you if there are questions from the bench, but only if there are questions from the bench do we allow you to go beyond the time period, which means that if you are answering a question from a judge, you of course may finish that question. If a judge has further questions, I allow the judges to ask further questions, but the limit of the argument is presumptively the time that will be on before you on the time limit, and that is going to differ because to render it equal for each of the sides. So with that, we may proceed. So I gather, Ms. Reynolds, you are beginning on behalf of the Worcester Housing Court.
May it please the Court, Your Honor. My argument will concentrate on the appeal. There are, of course, miscellaneous motions that have been referred to the quorum, but I will rest argument on those papers unless questioned. So as to the appeal itself, this Court should affirm the single justice rulings in both cases that I'm arguing, that being the Adjartey case and the Hilton case. My brother will be concentrating on the Evans case. The 2 primary reasons to affirm the single justices in Adjartey and Hilton cases are that the single justices neither erred nor abused their discretion when they dismissed or denied the petitions. As we argued before the single justice, Chapter 211, Section 3 powers of this court are extraordinary and to be exercised sparingly as needed, not merely as another level of appellate review. And the petitions don't meet this standard. They don't meet this standard for several reasons. One, as in the Adjartey papers themselves, the petitioners have admitted, it's in the appellate record at page 135, that all petitioners could have appealed the denial of any access to a CD. Even if they had not made that admission, it is clear that appellate review of the issues raised in the petitions is available in a variety of manners, both interlocutory and at the end of the cases, through various statutes all cited in the briefs. And further,
before we leave that issue, assuming for the moment that you might be right about the fact that the avenue of appeal is not to the single justice but to the appeals court on that, is there an issue of superintendence that's appropriate for us to address in terms of the clarity of the process to obtain a CD?
No, Your Honor.
Sorry?
No, there's not. There's no need for this court to exercise superintendent's powers to clarify how one obtains a CD.
And what do you say right now is the procedure as we speak?
The procedure is to go So I'm assuming we're in the context of an indigent applicant, or?
Of course.
Yes. The procedure would be to fill out a form requesting the CD and pay the fee. If there's not an ability to pay the fee, then they're to request waiver of the fee under the indigency statutes, Chapter 261, excuse me. And of course, most of the CDs that are requested in this matter are under this court's ruling considered extra costs, not normal costs. So a hearing may be required to determine whether those particular costs should be waived.
Where have we determined that the cost of the cassette copy is an extra cost?
It's a 2003 ruling of this court. It was under when Chief Justice Marshall was with the court. I could submit as a post-argument.
So we've decided, because is that one of the cases in your brief? Because which case is it?
It's not, I could not find a case for it. It seemed to be simply a memo of, that there's statutory authority for, under Chapter 261 for this court to set the costs, what the costs will be, and to determine these things. And I'm not sure, I could not find the process.
So it's not, it hasn't been done in a decision. It's done in some kind of, you're saying it appears in some kind of issuance of the court that's not a formal decision, though.
Right, it's in the form similar to what I've seen in recent years of this court's approval of a rule where all of the justices said that this is how it shall be.
So it's pursuant to our superintendent's authority, if it's part of our, if it's related to our rulemaking. Correct?
Yes, as I understand it, this court has had rulemaking authority that even predates the Massachusetts Constitution, so I'm not sure that it's necessarily part of your 211.3 authority. It may just be inherent authority that this court has. But it is a 2003 decision. And then several years after that, because originally the forms were all paper, and then several years after the original ruling, there was a form, the paper form was reissued for electronic submission, and that sort of carried forward that same decision as to what's a normal cost or an extra cost. I'd be happy.
You don't think it's time to revisit that?
The Central Housing Court would have no position on that. That's a matter of this court, within this court's discretion. That's a policy matter, and certainly within this court's discretion to do so. We just don't take a position on that.
Okay.
The petitions should also be, the single justice decision should also be affirmed because even if the subject matter of the petitions was a proper subject matter for this type of extraordinary relief, the petitions themselves were properly denied as a matter of law because the petitioners failed to name as respondents all of the parties in the Central Housing Court proceedings below that they wish to, quote, unwind. That requirement is found in Rule 222, and therefore there's no basis for the single justices to grant relief. I'd also mentioned that this court is loath to second-guess single justice decisions, not to address claims of systemic error, and that that's well established. The Abernathy case cited in my brief, and there you are familiar with others. Further, I would say that even in this court, the briefing has failed to rise to the level of proper appellate argument, as argued in my brief, that they just seemingly sort of ignore what the single justice had done, and they haven't spoken to why the single justice erred or abused discretion. And so for the failure to properly present appellate argument, it's a further reason to affirm. If there are no further questions, I will ask you to affirm and rest on my brief. Thank you.
All right, thank you. Mr. Linehan, you have 7 minutes.
Good morning, Your Honors. May it please the Court. My name is Brian Linehan on behalf of Federal Home Loan Mortgage Corporation.
If the court does not have any specific direction, I'd like to begin with the issue of mootness of Ms. Evans' appeal. This was raised in a motion to dismiss and also raised in the appellee's brief as well. The matter of Petrillo versus Petrillo-Alfiero seems to be dispositive of this issue. In the Petrillo case, the occupants were defendants in a summary process case. The landlord obtained a judgment of possession. Prior to the levy of the execution of the judgment of possession, the occupants filed a petition to a single justice of this court under 211 Section 3. That petition was denied. They then filed an appeal of that denial. A day after they filed their notice of appeal, the landlord levied upon his execution and removed the occupants from the property. And this court held that because the occupants were no longer in possession of the property and they had been removed and the eviction had been completed, that this court could no longer grant the relief that was requested in the petition, which was a stay of the execution.
And is it your view that that's the only relief sought by Ms. Evans?
That is Ms. Evans' petition sought preliminarily a stay of the execution, and she filed two other 211 Section 3 petitions to stay the execution. And in furtherance of that request, she makes a number of challenges to the conduct of the housing court, the rulings of the housing court, and also of the parties as well. However, in essence, she was seeking a stay of the execution. And Justice Budd did deny that petition, and that was on May 4th. And later that day, Freddie Mac levied upon its execution and removed Ms. Evans from the property, thus completing the eviction. So this court now lacks power to grant Ms. Evans' request. Now, also in the appeal...
Now, you know that she has claimed that this was in violation of a bankruptcy stay.
I do, Your Honor. However, it should be noted that, so the review standard for the single justice denial is for abuse of discretion, and the Conkey versus Commonwealth case sets forth a two-prong application of that standard. And first, Ms. Evans has to claim a violation of her substantive rights, and that violation could not be remedied through the normal appellate process or through adequate alternative remedies. With respect to the bankruptcy stay, there is a pending adversary proceeding in the bankruptcy court where Ms. Evans can resolve any and all claims of a violation of the automatic stay. Now, whether or not Ms. Evans' claims have merit is irrelevant for the purposes of this court's determination as to whether or not Justice Budd abused her discretion. The point is that Ms. Evans is now proceeding in the bankruptcy court to resolve those issues before Judge Panos, who in the transcript excerpts attached to Ms. Evans' reply brief specifically says that he will retain jurisdiction over any claims under 362K under the bankruptcy code. And so Ms. Evans does have an adequate alternative remedy for resolving those bankruptcy issues. And the same goes for her claims, her challenges to the underlying summary process judgment. She filed a motion to vacate that judgment, arguing that the judgment was void. However, although she noticed an appeal of the denial of that judgment, she failed to pay the use and occupancy payments, and her appeal was dismissed. Now, that use and occupancy payment did initially go up to the single justice of the appeals court. It was initially both a use and occupancy payment and a bond. The single justice struck the bond, remanded back to the housing court for a determination as to the fair value for use and occupancy, which was set at $1,062. Ms. Evans failed to pay that. Her appeal was dismissed. If she wished to challenge the underlying judgment of the housing court, she could have paid that use and occupancy and proceeded with her appeal. And that is specifically set forth in this case decision in Wallace, as well as the appeal bond case as well, I believe, which was filed as a notice of supplemental authority of this court. In those cases, there was a pending appeal, and the court recognized you had the avenue to challenge the underlying judgment. You could have proceeded with your appeal, and you failed to do so. And the defendants in those cases then could not come to this court as either an alternative appellate remedy or an additional layer of appeal. That's not the purpose of Chapter 211, Section 3. Ms. Evans also claimed violations of her rights under the Americans with Disabilities Act. Similarly, she could have remedied those through an immediate right of an interlocutory appeal. That's set forth in the McDonough decision. Ms. Evans is a witness testifying on her own behalf in the summary process case, which the McDonough decision is unclear whether it applies to parties as well, but as she is a witness, the standard seems to apply. And in that case, Ms. Evans, let me back up, Ms. Evans' challenges to the rulings of the housing court are that the housing court conducted a hearing and asked her to discuss her disability on the record, and she felt that that was a violation of the HIPAA rights, and she felt that her request for an accommodation was reasonable and was improperly denied. However, in McDonough, this court did set forth the standard in that if there is a request for an accommodation and that is either contested or there's a question as to the reasonableness of that request, the judge is required to conduct a hearing and make inquiry as to the nature of the disability and the relevance of the request on the record. It's specific in that decision. And the reason that that inquiry has to be on the record is because the judge, if denying that request, then has to issue written findings sufficient to permit appellate review. And that decision in McDonough specifically states that because that could affect the overall substantive rights under the Americans with Disabilities Act, if the request is denied, there is an immediate right to interlocutory review by a full panel of the appeals court. So when the housing court denied Ms. Evans' request, Ms. Evans could have, within 30 days, filed a notice of appeal and taken that up to the appeals court, which she failed to do. And she failed to prosecute her appeal of the underlying summary process judgment, where she could have raised that issue as well. And so because she had adequate alternative remedies to resolving the issues that she outlines in her brief, Ms. Evans' petition under Chapter 211, Section 3 is not proper exercise of the court's general superintendent's power. And I can see that I am almost out of time, so if the court does not have any questions, I can rest on the briefs.
All right, thank you.
Thank you very much.
Ms. Evans. Which one's Ms. Evans? Ah, there you were. Ms. Evans, you have 5 minutes.
Thank you. First, I wanted to address the issue of ex parte communication that was submitted by the appellee to this court on October 5th, I believe it was, of this year. After the court scheduled oral arguments, they submitted documents to this court, ex parte, and in their certificate of services page, they asserted that they issued it to the petitioner. Petitioner never received any documents from the appellee, and recently they submitted an opposition to a motion that the petitioner submitted saying that they had sent it to the address that the appellee just testified that on May 4th, they executed an execution and evicted her from her home. So if they sent out documents to that address, knowing that the petitioner would not receive those documents, then they just admitted that they submitted documents ex parte because they have no reason to believe that I would receive those documents at the address that he just said they executed an eviction notice on May 4th.
And have you furnished them with an address that is a proper address?
In fact, their certificate page has my P.O. box number that they've been sending me material, including their brief. I receive a number of mail from them, but for some reason, when they wanted to submit this document to the court and mislead the court that they sent it to me, they somehow found their way to sending it to the address that they know, that they should know, that 580 days ago, they unlawfully executed an execution that was obtained. It was void ab initio because it was obtained during the stay. They continued during the stay to conspire with the housing court judges and the housing court judge, Judge Theophilus, on April 11th, a day after the appellee went to the bankruptcy court and asked misled the bankruptcy court, as a matter of fact, that they didn't know, they weren't sure they were under automatic stay. The bankruptcy court confirmed that they were under a stay, and the bankruptcy court refused findings was that it was not going to lift the 14-day stay that was left. While they were in court, at the bankruptcy court, they already had a state court hearing. So while they were in the court, asking the court to explain to them, for an emergency determination hearing to determine if they're still on their stay. They have a hearing scheduled for the very next day, April 11th, to reissue an execution that they know. They didn't explain to the bankruptcy court that they had this hearing, and they went to the court on the 11th and got that execution reissued during the stay. And because they did that, they violated the automatic stay. And in turn, they didn't just violate the stay, they also disobeyed the federal bankruptcy judge's order not to lift the stay. And he's sitting here saying that they executed. He's actually admitting that he did these things, because if they executed anything on May 4th using that execution that they obtained on April 11th, it's a violation, and they must reverse the actions that they took on May 4th.
What he has said to us is that if there's a violation of the bankruptcy court stay, that there apparently is still a pending bankruptcy action, and that you may
Yes.
seek relief in the federal bankruptcy court.
Right.
So why is he wrong about that? Why is he wrong as to that
Why
being your remedy?
he's not necessarily wrong about that. What he's wrong about is that they were able to levy, he's misrepresenting their ability to come to petitioner's home on May 4th with an execution that they obtained during the stay, and break her door down, break her door, enter her home, send paid police officers to search it. Then they turn around and send men in to take her stuff, throw them in plastic bags and boxes. That is what he's misrepresenting. They had no ability to do that because they obtained a void ab initio execution during the stay. And the appellee also knows that this case, the case that I raised, the 211-3 petition, is about judicial and professional misconduct. It's not just about the bankruptcy, it's about the many violations that has happened in the state court during this case. He also knows that because Judge Horn, as he stated, issued a default judgment when she violated petitioner's rights at every turn. She violated on May 25th, June 1st, June 6th, and even the day of the trial. Petitioner requested continuance for good cause because her attorney had suffered a heart attack less than 2 weeks before the trial, and she wanted to retain new counsel. Judge Horn denied her. The appellee did not turn over discovery documents that they were supposed to turn over, that she needed to make her case. In fact, that was the reason she had to obtain a counsel, because she was having trouble getting the discovery. Five times, Judge Horn issued an order that the appellee should turn over discovery documents to her, and 5 times they refused. She asked for the continuance. She also filed a motion asking for the case to be dismissed because they were not following the discovery rules. The judge denied that. She went back on June 1st, and because of all the things that were going on, she has medical disabilities that were being exacerbated. Petitioner went back to the court at a hearing and asked again Judge Horn for a reasonable accommodation on the Title II of the ADA. Judge Horn, she had a doctor's letter from her neurologist who specialized in neurology. Judge Horn denied it. And then the day of the trial, petitioner her medical disability was so exacerbated, she went to the court to partake in her case, but was too sick to do so. Illness from all the desperate treatment she had been receiving up until that point from the housing court, from Judge Horn in particular, caused her disability to be so exacerbated that she could not participate in her case the way that she wanted to. And because the appellee did not turn over discovery documents, she did not have the documents she needed to build her case, and because her attorney suffered a heart attack, she did not have the help she needed to prepare the case. She, again, filed a motion.
I understand. I'm afraid your time is actually more than up.
Yes.
But so thank you, and we'll hear from Ms. Hilton.
Okay, thank you.
And Ms. Hilton, you have 5 minutes with regard to a separate case. Yes, you may
Your Honor.
proceed.
Thank you for your time.
For the record, we honor the protocol of the court. We do want to inform the court we requested more time in a special format given that we are dozens of pro se litigants. We cannot represent each other. We were not denied our format request submitted November 7th. So arguably, we are here because the Worcester Housing Court specifically strips us of our right to self-represent. It does let us argue laws or jurisprudence. It refuses to recognize, address legal argument. Literally, we are told not to speak and denies us our notes. This court must make clear that the clerk telling us that only a few can present is not to be taken as acquiescence that a court may strip pro se litigant of their full range rights to represent as fully as any lawyer. The case I am lead litigant on commenced because of extensive quizzing of litigants by the judges in the Worcester Housing Court, seeking to drop charges on us for unlicensed practice of the law. What was rampant. Decisions written included dropping charges, and I had just received in writing that the court had opened the investigation on the WAF members. We have never been told that it was closed. By the time this arguing is done, it will be video record, and we have never represented ourselves as lawyers. We need this court to state as soon as possible that this court will look very unfavorably if this oral argument is used to back criminal charges. We need these clarifications by the time this tape is available. We recognize that any written decision from this court will take much longer.
Can I ask one particular question? In your case, do you have the $50 CD in your particular case?
I have it.
So they asked you to pay the $50 for the CD.
Oh, actually, no, I don't
So
have
that's
that, I'm
not-
sorry. I thought you
I'm-
meant the evidence I tried to submit.
I'm trying to understand
Sure.
whether your particular case involves that issue or not. I know it's in the Adjartey case.
I'm indigent, and
Right. But were you asked to, did you try to get the CD and the $50?
I did try to get the CD, and I wanted to get the recording of each hearing, but I couldn't
I'm just
afford it.
trying to understand the basis of the $50 rule. It seems to me it's based on an affidavit form as opposed to any legal analysis. But I also
An
trying to
affidavit form.
understand whether it involves, and not a rule of the SJC, but just literally an affidavit, a form affidavit.
It is a form.
But is it raised in your case? I know it's raised in the Adjartey case. I'm just trying to understand if it appears in your case.
Yeah, that's not my main focus.
I understand it's your main focus, but I'm just trying to know which cases that applies. It would be useful if I knew it applied in the particular one you're bringing.
Yeah, no, I did not, because I
Okay.
didn't have the $50, to be honest. That is true. Thank you.
Okay, you may proceed.
Okay, sorry. In the preamble of the Massachusetts State Constitution, it states, "It is the duty of the people, therefore, in framing a constitution of government, to provide for an equitable mode of making laws, as well as for an impartial interpretation and a faithful execution of them, that every man may at all times find his security in them." Sadly, this is not the case of the people of Massachusetts, who must represent themselves in the Worcester Housing Court as pro se litigants and members of WAFT. The denial of justice and disparate treatment of pro se litigants against paid attorneys is an egregious act that happens all too often, and I'm hoping this court will not allow this abuse to continue. The fallout from this treatment is not only damaging to us on an individual level, but this has a ripple effect of the entire justice system of Massachusetts. This is what I thought you were referencing, I'm sorry. This was kind of nervous. I tried to get my video evidence in for review, which clearly shows my foreclosure auction was void. So in turn, the foreclosure deed and affidavit is void. Since a foreclosure is a physical and auditory event, I needed that evidence to prove that clear point. There was only one person there representing anyone on the other opposition side. I tried 5 times to submit my video evidence to the Worcester Housing Clerks and the Honorable Judge Theophilus with service, affidavits, and even a motion. My evidence was even attested by the videographer. It was denied. And I even gave the court the rules of evidence from this court in my motion and in court, but no luck.
Okay, thank you.
Thank you very much.
And Mr. Schumacher. And you also have 5 minutes. And you may proceed.
Thank you, Your Honor. Good morning, Your Honors. I think it's still this morning. I guess it's afternoon. Good afternoon, Your Honors. The Worcester Housing Court refuses to address the standing requirement in summary process cases. Even when it is raised, and especially when it is raised by pro se defendants. This has been a repeated problem for the pro se defendants trying to seek justice in the Worcester Housing Court.
Now, when you say the standing requirement, I assume you're familiar with our Hatcher decision.
Yes.
And are you saying that that after their Hatcher decision, they are not recognizing the obligations that that decision sets forth?
Correct. I raised the issue several times, but I think it was May 5th in 2014. I used some of the very same case law that Your Honors quoted in the Hatcher decision and made the same arguments, and they were ignored, and they continue to be sporadically applied or not upheld. I think the crux of my biggest concern here for my participation in this is the simple fact that Your Honor's decisions are not receiving the traction that they should in the lower court. And the rules are not being followed consistently for pro se versus attorney-represented cases. So, yes, unfortunately, your decisions are not reaching the lower court, and this is an alarming problem, not only for those you are listening to today, but for many others that have to go into that courtroom. But I'll return to my written statements here. In fact, I will say this though, two of the cases that were referred to in my brief back in 2014, I mean, imagine 4.5 years later, we're still fighting over the paramount requirements and importance, critical importance of standing. I quoted from Ratner and Hogan, and also from HSBC Bank and Matt. Again, those were cases Your Honors referred to in the Hatcher decision. So it would be wonderful. I mean, much of this challenge would be alleviated if simply your decisions saw the light of day in terms of not just theory, but application in the lower court. For example, when I made the arguments at Worcester Housing Court regarding the plaintiff's lack of standing several times, and it was a central part of my argument, under my 60B motion of May 5th, 2014, which I just referred to, I even cited several key cases, such as the ones I mentioned. I specifically walked the court through each element of the plaintiff's lack of standing in the matter, as well as the lack of subject matter jurisdiction. Rather than affirming or refuting any of these points, the subsequent decision of the court made no reference by these elemental issues, no reference to these elemental issues, which are dispositive of the ownership of the property and critical to the transfer of rights of property. Repeatedly, when I made arguments at various stages of my case, I would refer to Your Honor's decisions, other higher courts' decisions, national and appellate decisions, appellate court decisions, and rather than receiving a decision from the court, either affirming or denying and explaining why these cases may or may not be applicable in mine, they were completely ignored and overlooked, as if I'd never raised them in the first place. And instead, other issues were presented in other decisions were not necessarily relevant whatsoever at times to the arguments before the bench. This is frustrating for those of us who are trying to seek justice and traction of the laws that you yourselves render from the bench here in Boston. The Worcester Housing Court failed to address legitimate issues and defenses I raised in controlling case law made by this honorable court. This constitutes a dangerous breakdown of our judicial system and a failure of justice and due process for everyone. How does a pro se litigant obtain an opportunity to be heard in the courts of our Commonwealth? I am here with my peers as a last resort in our plea to have your esteemed attention and action. Your decisions must be properly enforced. Any abrogation of these rules and edicts elicit a critical erosion of due process and justice. Please help us. Please help us enforce your laws and protect our rights under the rule of law so that our most basic constitutional rights are protected and indeed implemented. It is now December 6, 2018, as I mentioned. 4.5 years ago, I made these very same arguments at the Worcester Housing Court, which fell upon deaf ears. Hopefully, your decisions today will help bring us up to speed.
All right, thank you, sir.
One last quick thing.
Yes, you may.
Thank you. The allegations of the affiliation of our group in defending our rights have been brought to a very challenging stance in the Worcester Housing Court. We are being told that we are being observed for criminal action of practicing law without a license, among other things. Our understanding, Your Honor, of what we are doing is protected by the First Amendment rights of the Constitution of the United States and also state law.
Excuse me, who is telling you this?
Judge Horan, Your Honor, sadly, I've witnessed it many times, including my own case. As part of our mutual aid, we often try to go to the courtroom for support and sit quietly and observe. When a defendant is presenting their arguments and their brief and their memorandum in oral argument form, often they're stopped by the judge and interrogated as to how they obtained this information and constructed the brief. And several times there have been verbal chastisement that indeed they suspect that there's being law practice without a license and criminal action is being pursued. This, Your Honor, is most grievously distracting to the defendant who is before the bench seeking justice and defense.
Are the questions directed at the person whose house is being, whose apartment is being taken, or are they directed at someone else trying to speak on behalf of that person?
Usually, at least the cases that I've seen, and I've seen over half a dozen times when this has happened, the defendant will be engaged in arguing their motion.
Right.
The judge, usually Judge Horan, will stop them and question their ability to write such a thing or present such a thing, and where did they obtain this, and warn them about criminal proceedings pending, and that she and her colleagues were prepared to go to the district attorney and orchestrate actions against the group. We're there to defend against the most fundamental right, our home, our rights of life, liberty, and happiness, property rather, under the state constitution. We're not there to be ostracized and interrogated with a sideshow of allegations that have nothing to do with our specific defense, and compounded with the fact that what we do present is often ignored, is just, salt water upon the wound. If such a thing were happening, and I do not believe for a second it is, there are better means to pursue that than to compromise the defense of an individual who is doing their utmost under great duress and financial hardship to protect and preserve their home for their family.
All right, if there are no further questions, thank you.
Thank you.
And Ms. Bent. Ms. Annette Bent? Ah, there you are. Take your time. And you too
Hey, Your
have
Honors.
5 minutes.
And I want to thank you for taking the time to hear us, because we're not accustomed to that. Today, I want to speak to you on the fact 2 ex parte documents being put into our files. I know I'm in Exhibit F.
Exhibit F?
F, yes. And I am going to be referring to the deed and the affidavit and the certificate of entry and power of attorney. These documents are slipped into files without our knowledge, which the Worcester Housing Court has admitted to putting into our files without service or without proper motion, affidavit, or entry form. We don't get to see them. We don't know they're there until we go through this. Sorry. And the summary process rule says that they're only allowed to put in summons and complaint and a notice to quit. Your Honors, this is a huge problem, as the documents are no good. Even if we don't know this, the courts have the responsibility to look at standing. And if they would look at this, they would see that they are no good because they don't own the property. I know we've looked at 55 examples, and if I could just quickly refer to these documents, they are my own. And I can tell you, just show you a little bit. In the deed, they put in a foreclosure deed with an affidavit. So you have the deed, and here's the affidavit. Okay, so they're supposed to be based on personal knowledge, something you experience, you see, you hear, you touch, you're there. This affidavit is signed by Michael Driscoll, who swears on his personal knowledge to what happened at the auction. However, all you need to do is go to the certificate of entry, and, thank you, certificate of entry, which is also the possession saying that he stepped on the property. Well, the name on that is John McCarthy. That is not the person who signed the affidavit. That party was not at the auction. This party, who claims to have been at the auction to represent the bank. So we know that this is not an affidavit, because the signer was not at the auction, was not on personal knowledge. This affidavit is not an affidavit. So that means what they gave the court was not a deed and an affidavit, as it was required by prima facie showing. It's at best a deed. However, the problem continues. If the court would now please look at the power of attorney that was associated with the certificate of entry, you will see that, yes, it identifies Mr. McCarthy, the guy who stepped on the property, as the party that was supposed to represent the bank, but he didn't represent the bank yet. If you look at the signature on the power of attorney, it's after the fact. Certificate of entry says that he stepped on the property on August 26th, and he didn't have any authority from the bank until September 30th, which creates yet one further big problem, because whoever was there for the bank when the bank claims to have bought it back is the one who signed the document to buy the property, what's called a memorandum of sale, which means that this guy who signed it, but he didn't represent the bank yet. So the bank didn't buy it back at auction. And Your Honors, you don't have to know me, and you don't have to know any of us. You just have to line up the documents from the registry that they file at the same time when they filed the foreclosure deed that shows the deed. Then you have the no good affidavit not on personal knowledge. This guy, he wasn't even there. And the guy who was there didn't have the authority yet. He's the one who signed to buy back the home. These documents show not only don't they have their prima facie case, but in fact, they did not buy this property back. They have no standing, and they are not the owner. So not only is the Worcester Housing Court biased, allowing them to put in documents with no service, no motion, no affidavit, or anything, which we would never be allowed to do. But those documents, if the judges would just even look at them on their own, like they're supposed to do, to test for standing, they would know that the bank does not own this property. And this is true, Your Honors, for every case that anybody from WAFT has ever looked at, to the best of my knowledge, the ones that I have seen, except for one. It was a local bank, and the party who stepped on the property was actually the bank.
All right. Ms. Spence, anything else? Because your time is up.
Oh, sorry.
Okay, thank you.
Thank you.
And I know there was some uncertainty as to whether we would allow Ms. Oliveira to be heard, but we shall allow Ms. Oliveira to be heard. And I believe you have an interpreter with you. And I will give you in view of the interpreter, I guess I'll give you 5 minutes plus another minute because of the time taken with regard to the interpreter. So Ms. Oliveira, you may proceed.
All right, thank you. I have disability for a long time, decades, but I was.
Well, let me ask you: are you more comfortable speaking in Portuguese or in English? Because we have an interpreter here. If you're more comfortable in Portuguese.
English.
English,
I have
okay.
right in English.
Okay, and if you're struggling for a word and you know it in Portuguese, the interpreter is there to assist you.
Okay, thank you. But I always, after years struggling, I find myself peace with the treatment, and I got my way back to a normal life until I met Judge Horror. I lost my ability to live in community. I lost my confidence, myself. I had my dignity stolen from me. I was at the ER for 3 days on morphine without food. And I missed the pre-trial conference, and I put a motion to postpone because I have a right to have a jury trial, and the judge just say that when I hear the tape, I wasn't present. I was at the hospital. She said to the clerk that it was suspect and disingenuous that I was in the hospital, and if I should check out and leave the hospital if I really want to participate in the conference trial. I don't know why she said that. I never met her before out of the court, and I'm not a criminal, and she said that was suspect and disingenuous. I was not discriminated against by the judge, but I was insulted. The judge denied my motion to postpone just because it was suspect and disingenuous. I had provided her with all my papers from the doctor, but she denied anyways. But the judge was willing to offer the plaintiff lawyers to postpone just because he couldn't reach his client. And she asked, "Would you like to postpone?" But I was in the hospital, in bad shape, because it was suspect and disingenuous. The plaintiff never provided any proof or evidence that they bought my house. The court, Worcester Housing Court, didn't have any documentation showing that they bought my house. I gave her the deed in my name, my husband's name, and I told her the house was mine, was for my family, and that she just say, "Well, they have the deed, right?" Addressed to the lawyer. And I copy for all the documentation of the court. They never provide her, she never had any proof, anything from them that they bought my house just because someone went to the court and say, well, I bought her house. Okay, the house is yours. And I don't think so. This is the way a court or judge work. I came to this country not to make money. I came here because I never was respected as a citizen in my country. If you try to pursue your rights, you end up dead. So I leave my family, I leave my country, my friends, so I could have a life with dignity, and I didn't find here. I'm trying not losing my hope in the system, in that this country is good. I don't want to just one person ruin my dreams. I'm trying. If someone asks me what I want the most in my life, I just said that I wish she was here so she can hear from me. And she see all the pain she's causing, not just me, but a lot of people. My kids is still struggling. Ask why. Why we lose our house? They born in there. They raised in there for 14 years. And then why we can buy back? She took all the memories and everything. And I have all the papers from the bank, all the wrong stuff. She even couldn't have the time to look at. She took away my rights. When I asked for the CD, I have a ADHD, depression, and I need here a home so I can prepare myself for a trial. And she just said that won't be necessary if you want. She can repeat everything again in court. She put me in the front of the whole court, so everybody knows I was indigent because I couldn't work at the time. Just to say no, to deny something is a minimal compared with a lot of stuff. I just need a CD, and I had to go in front of the court and explain that I'm indigent. So she denied my rights to have a reasonable accommodation, which the bankruptcy court judge panels understand and treat me well, with respect. And I never could understand why she was doing that. Why? And Robert, she's never gonna answer that.
Okay. Ms. Rivera, thank you. And we will now adjourn. Thank you so much.
All right.